what are some things that we need to talk about when we are going into a separation, right? What are some layoff and reduction in staff considerations? And the first one I always talk about is the WARN Act. And a lot of you are just going to kind of shake your heads and say, it doesn't apply to me. I don't know enough people. So that's fine. And that's great. But if you grow and you get bigger, you might have the problem. And you know what? Sometimes businesses get big quick. Okay. And you might not know you have 100, or you might say, look, what are the general rules for WARN Act? And it's pretty simple what the WARN Act is. You got to know what it is. The general rule is, do you have 100 employees? Yes or no? Okay. If you know you have 100 employees, it's usually pretty good. And then how many people are you going to lay off? That's the general rule of thumb is if you have 100 and you're going to lay off 50, you might be in trouble here. Okay. I think that's when you get yourself into a potential situation. But counting employees is a little bit difficult because you sometimes exclude people working less than 20 hours when you count, but you have to give them notice when you have a WARN Act. And let's just say you're going to have a major layoff of production. All right. So you have a group of people that you're going to lay off. We take a look at how many people are going to be affected. If we're going to be near 50, let's go ahead and do the math. We could literally sit here on the technicalities of the WARN Act for hours and talk about it. There are some issues that come up, but for the most part, you have two types of WARN Act required layoffs. You have a mass layoff, okay, that triggers that. And that means that you have these 50 employees, okay, excluding your part-timers, working less than 20 employees. And that represents at least a third of your workforce, unless you have like 500 employees. And then you get rid of that 1/3 of the workforce rule. Okay. Now that's triggered potentially. And then you have notices. And you don't just send notices out to the employees. You've got to send it to somebody specifically designated in the state, as well as the highest political official in your local area. And if you have a union, you've even got to send it to the union rep. You got a lot of notification procedures. Now, the other way you can trigger this is a plant closing. A plant closing can happen, and that's not just, hey, we just decided to shut down a plant. It actually could be a unit within the plant in a single location. Of course, as always, statutes have all kinds of meandering rules about what's a single location. You might have thought a single location meant a building, but it doesn't. It's actually a little bit more complicated. There could be another group where people go back and forth across the street, and they say, well, that's all the same thing. And in that case, again, if it's 50 employees, of course, it's 50 affected employees, which means if you're going to, there's an example in the DOL rules that says, oh, we decided to lay off all of our accounting department, laying them all off, 45 of them. You go, oh, we're safe. Well, wait, because of that, 5 other clerical staff are being eliminated. Uh-oh, now we've got 50. Okay, well, now we might have a requirement to send out a notice. And the notice can't just go out the day beforehand. It's got to go out 60 days in advance. And if you don't know whether you're supposed to put that notice out or not, and you haven't looked at it 75 days ahead of time or whatever, you could have yourself a problem. Because what can happen is there's damages associated with this, and the damages are pretty significant. Everybody gets up to 60 days of pay, depending on what the notice is. If you give it late, you can still kind of offset it a little bit, but you get 60 days. You get a statutory fine. And the best of all for attorneys, you get attorney's fees from the court. So everybody, let's just say you had 100 people you laid off. Every one of them is going to get 60 days. Uh-oh, that's going to add up pretty quick. And then some attorney might go ahead and say, well, I'm going to represent all these people. I've done so much work adding all these numbers up that I'm going to get attorney's fees for this. So it can add up pretty quickly.
And what the even worse possible outcome is, instead of one attorney representing 100 people, you get 100 attorneys representing one person.
Yeah, exactly. Yeah. So you could get yourself into a world of hurt without knowing what's going to happen. And I don't want to go down into the details of the WARN, but the WARN notice is not just a, hey, by the way, we're closing down. There's actual specific information that's got to be on the notice. You need to work with counsel to make sure that the notice is, 1, addressed to the right people, 2, done timely, and 3, has all the right information on it. If you're doing a layoff, please think about it and don't get cute, because the statute at first says, well, we're looking at a 30-day period. So in other words, I lay off on day 1, and then I lay off another 10 people and another 10 people, but you add it up and you've got yourself 50. But then in another section, the preamble, it says, well, actually, we're looking back 90 days. And every time you do a layoff, it resets that calendar. So if you're laying off and you're going to hit 50 aggregate, you can get yourself in trouble if it's part of the same reason. Then you've got yourself a problem because you didn't actually give the notice. And you've got to update these notices. And let's just say it's going to get pushed back because of some circumstances. There are opportunities, depending on how long you're going to push it back, to just send a notice and say, hey, sorry about that. We were going to lay off on this date. We decided not to. And generally, they give you a 14-day window that you can give a notice for. But if it's for a longer period than, say, 60 days than what you initially said, you actually have to resend the notice out altogether as if it's a new layoff notice. And every time you don't do it properly, you've got a problem, and there could be damages in this. So we have to be careful. Don't get cute with your layoffs. Now, there are some exemptions for this too. So, for example, the exemptions would include unforeseen business circumstances that were truly unforeseen at that time. That's a legal issue. I would definitely talk to your counsel if that's what's going on. What you can't do is say, I've been watching how bad things are going. I've decided to lay some people off because things just aren't going good. The board's on me. I got to make some decisions. That's probably not going to fall into it. There are some, force majeure issues that come into this, but you have to fit into the exemptions, right? That's number one. Number two, we got to watch out for. We're going to sell the business. We're going to sell it. We're going to merge. We're going to be purchased. It's going to be an asset sale. It's going to be a non-asset sale. It's going to be business, whatever the deal is. Technically, if people are going to be fired from your business and then hired by a new business, you're under the auspices of the WARN Act. You may have to send out a notice. Or on the other hand, you might not have to, because there are some exceptions in here that are good things, which means, yes, you're being fired by company A, but good news, company B is going to hire you all off, and they're going to give you the same or similar job, same or similar wages, in the same or similar geographical area. Great news. We're probably not going to get WARN, or if only a couple people are going to be affected and not have same job, you probably aren't big enough as far as a layoff for that. Unless, of course, you try to keep it a secret and don't want to tell anybody about the sale until the last minute. Then all of a sudden you did know about it. And it turns out the seller says, well, all of your people, now that I'm looking at them, they're terrible employees. I don't want to keep them. And now what happened? Now they don't hire the people. Generally, the rule of thumb is the seller is responsible for the WARN notice, period. And unless the decision to let go happens after the sale. Now, if they decide, hey, we're going to bring you on, and they go, you're all terrible, we're laying off 100 of you or 75 people, they could have some responsibility. And I'm not going to get into this because it's probably going to be talked about Rob and with Carl in a couple of minutes, but that's something you can talk about when you're negotiations. But the long story short is WARN Act is important. All right. I think it's important to remember layoffs, making decisions. And there are exceptions. If you give people early retirements or if they're terminated for cause unrelated to the actual layoff, they don't get added, but you can't get cute because there are real world exceptions. And the people that drafted the law knew that people would try to bring things up. So I just think that's a general 30,000 foot view of the WARN. I don't want to get too much in it, but if you do have questions, I do strongly suggest you call one of us to talk about what you're doing, whether it applies or not, because it's very fact specific. Now, one of the other things I wanted to talk about a little bit was how to avoid discrimination and retaliation claims during layoffs in general. Well, this is a very big deal. I talked about the EEOC getting rid of the disparate impact for their analysis. That does not mean that it won't be used during a lawsuit by an individual and addressed by a court. And I'll tell you, one of the factors that comes into play a lot is age. When you're doing a layoff and you want to issue an age, and I don't want to step on the toes of Rob and Carl when they talk about how to do separation agreements, age is not only a major factor in layoffs that a person could bring a claim on. If you do get a sign off and a release, the nature of a release that you get when you're doing a layoff or you're offering terms, it's different than any other release that you have. You have to have special language for older workers. So it's very important. So they'll probably address some of those issues, but I won't get into it. But you got to look at, are we going to have people that are over 40? Under federal age law, 40 is the big issue. All right. Are you over 40 or under 40? According to the federal government, when you're 41 years old, you may be senile because you have 7 days to rethink whether or not you want to sign that or not. You have buyer's remorse for 7 days. If you're 39, you're crisp, smart as a tack, you just sharp as a tack, you're out there signing documents, but not 50-year-olds. They can't do it. They can't be trusted. So there are different rules based on these things. Who are we going to lay off? Are we laying off only the females? Are we laying off 10 people? 3 of them happen to be the ones that just raised a claim about, hey, it's unsafe in this place. This is not a very nice place. Are we only laying off 7 people and 6 of them just went out on FMLA? We have considerations that we need to look at when we lay people off that go to common sense. What's the impact? So we look at, why are we doing it? Do we have a rule of thumb? Does our handbook address layoffs? Do we do it based on strict seniority? Do we have a union contract? If we don't have a union contract, what do we do in our handbook? And what is our practice? When I look at how to defend a discrimination case, because this happens a lot, people get laid off, they get offered a severance, they say no, or maybe sometimes yes, and then they come back and say, I think it's because of age. I think I was included in that group of 50 people because I'm old. Or I think I was included in there because I am in any particular racial category or any particular religious category. And you have to be able to say why. And a lot of times employers say, well, look, we just put the best workers. We went around the managers, we asked them, who's the best? And they said, well, Johnny's the best. So don't lay him off, but Susie's a bum. Okay, that's great. Why is Susie a bum? Is there some articulable reason that we could put in front of the EEOC or a judge or somebody on that jury that you could walk out on the street and tell them, this is why we laid this person off? And they would go, all right, makes sense. I don't know if I would do it the same way, but at least it's a legitimate, non-discriminatory business reason. So think about those things. Considerations for rehiring and post-layoffs. Again, the WARN Act only applies for long-term layoffs of 6 months or more generally, okay? But your layoff might be for less. How do you want to address it? Do you want to have a system in place where you give people a separation agreement? You're calling it a layoff, but in reality, you're firing everybody, okay? You want to articulate what the heck you're doing to people. Don't tell them, oh, you're getting laid off. Oh, okay, I'll sit by the phone and just wait. Well, you're giving people the wrong expectation. You need to let people know. Look, we hope this is a short-term layoff, but we don't know, right? That's an honest statement, okay? If you're saying to people, look, we're laying everybody off, we just don't have work, we just don't think it's going to happen, we wish you the best, but please go look for a job. We don't know. Or it could be, we don't have a clue. We will be calling you if we have a chance. And then you have an internal process. You have to think through before you do it to the extent you can. What's our process for recall? Is it going to be by department? Is it going to be by need? Is it going to be, by area? Is it going to be by seniority? Is it going to be by, we go to the managers and say, what do we need first? There's a process that should be documented to help protect you from any type of litigation. And I always say, I understand things happen fast and everybody wants to get things done. There's an operational decision and then there's a human resource decision. They don't have to be mutually exclusive, okay? They can work together most of the time to try to make sure that we have one sound reason. People need to work together. And if there is a reason to get rid of somebody that's not lawful, that reason should be eliminated. Simply put, because if you don't eliminate it, somebody will most likely find it through litigation. The other thing is, and all the attorneys on here will say, if you ever get sued, there's something called discovery, and they ask for everybody's emails and everybody's text messages and everybody's memos. And if you have one of those memos, a loose statement that looks really bad, then it might give the person a claim, even if you didn't mean it. So you have a little note on there, age, by somebody who's 72 that you laid off along with the other employees, but kept all the 20-year-olds. Guess what? You might have meant, hey, this person's great looking for their age. I don't know, but you better not put that on there. And if you write a text message saying, let's get rid of all the old guys and get some new blood in here, you're going to get sued and they're probably going to have a chance to win. Okay. Be conscious in your decisions and in your writing. So again, those are the best practices, in my opinion, of what we do when we have to consider laying off people. We have a WARN Act, it's an obligation. We have various laws about disability discrimination, age discrimination, sex, race, all those things should go into play to make sure that we're not focusing on that. And I think if we do that and we consider the process for laying off who, what, when, where, and why, what the decision makers are, and we have the rehiring understanding of what our process is, it helps us go into the next step, which is if you want to give people separation agreements at the end, that you will have already gone through a process to get there. But I will say people get sued for retaliation and for other discriminations because they do not think through their layoffs. And that's been a consistent source of litigation that I'm seeing this year. I'm in a number of litigations and claims before different agencies right now on this very issue. So I'm speaking from just past experience, but the fact that some people just don't like being laid off and they don't want to hear what you have to say. The best way to approach this is have a system.